The Court of Appeal on Monday affirmed the ruling of Chief Justice Roxanne, which stated that Election Petition number 88, which was dismissed by her over 2 years ago, is without merit. The decision was made by Chancellor of the Judiciary, Justice Tiana Cole Edwards, and Justices of Appeal Don Gregory Barnes and Richie Prasad. The main parliamentary opposition had appealed Justice George's ruling in Claudia Thorne and Heston Bostwick versus Keith Lowenfield, arguing that the Guyana Elections Commission, GECOM, handling of the March 2, 2020 elections had violated electoral laws and the Constitution of Guyana in serious enough ways that the results of the election should be deemed void. Petition number 88 challenged Recount Order number 60 of 2020, under which the national recount of all votes cast in the 2020 general and regional elections were done. The petitioners Thorne and Bostwick had also argued that Section 22 of the Election Laws Amendment Act 2000 was unconstitutional. As such, the Court of Appeal determined that GECOM was empowered to take all necessary steps to resolve the problems that arose during those elections, including putting Order number 60 into effect to make sure that the results were fair and delivered in a timely manner. Consequently, the appellate court dismissed Thorne and Bostwick appeal and ordered them to pay 4 of the respondents a total of $600,000 in costs. Justice George, among other things, had ruled that GECOM acted in full compliance with the Constitution and electoral laws in its conduct of the elections, and that neither section of the Election Laws Amendment Act nor Order number 60 was unlawful. She had held that a recount order was intended to resolve irregularities, discrepancies, and anomalies occurring in the election process and to determine a final credible count. Following the ruling, attorney-at-law and senior counsel Royce Ford, who represented Thorne and Bostwick, when contacted by Nightly News, related that he is yet to peruse the decision.
At this stage, we haven't, as you know, seen the decision and had a chance to really study them. Once that is done, we will make our decisions.
Last year, the Caribbean Court of Justice, CCJ, determined that the Court of Appeal erred in assuming jurisdiction to hear the opposition's second election petition, petition number 99. That petition was dismissed by the Chief Justice due to improper service rendered to former President David Granger. Attorney General and Legal Affairs Minister Annie Nandalal had argued before the CCJ that the petition could not be appealed since it had not been decided on its merits. Tiana Cole reporting for the AHGP Nightly News.